in cause number 2022 DCV 2486, Terry Finklia versus Pay and Save Inc. at all. Announcement of council, please.
Good morning, Jonathan Alyssa for the plaintiff.
Your Honor, Hugh Lyle for the defendant, Pay and Save.
Eugene Kim for defendant, EP Samana.
Good morning, council. If I recall correctly, Mr. Baeza, you had concluded at least a portion of your argument. I don't know if we're going to hear any more, but Mr. Lyle, you had requested some additional time for argument or to respond after Mr. Baeza.
That's correct, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. I will try to be brief since we've had the brief recess. I've tried to streamline this a little bit. For the courts, needs no refreshing, but we had 4 motions, 2 with EP Samana and 2 with the plaintiff. I think we're done talking about the EP Samana issue. I think it's a question of law for the court to determine whether or not the contract provision with regard to indemnity complies with the express negligence doctrine. I think that's where we are on it.
I'm sorry, say the express doctrine again.
Negligence doctrine. I apologize. But anyway, I believe that Mr. Baeza had finished his, had concluded his response. Couple of housekeeping matters to begin with. The plaintiff attempts to utilize photos which were taken by unknown photographers at unknown dates and simply attaches them to the motion without complying with the rules of civil procedure with regard to summary judgment evidence. And we believe that they don't constitute admissible summary judgment evidence, and we had objected to that, bring that to the court's attention. Also, as a matter of housekeeping, and I don't really know why, but rather than just provide the court with some additional authority, they marked as exhibits proceedings from another court case. And again, those aren't proper summary judgment evidence either. The plaintiff's argument, Your Honor, is replete with conclusory statements without any support within the summary judgment evidence. As an example, as to notice, there is no evidence whatsoever that Pay and Save had any actual knowledge of the condition in question. So there is no actual notice issue, and plaintiff kind of glosses over that and kind of talks a little bit about either actual knowledge or constructive knowledge, but with regard to actual knowledge, there is no evidence of that.
Mr. Lyle, let me stop you right there. Mr. Baeza, can I get a response to that, please?
Yes, Your Honor. In regards to notice, the notice question is answered by if the condition was there long enough for the occupier here, Pay and Save, where if they would have done an inspection, or if they had employees in the area, was it long enough there if they would have complied with their duty with inspections, or their employees had enough time to notice the condition, that counts as notice. Just because they're not saying, hey, I never saw it, that's not the issue. The question is, was it there long enough? And there's testimony from the landlord that says he believes it was there longer than the day. It wasn't there on the day, it wasn't water. And there's evidence that employees for Pay and Save were in the parking lot, 1 employee at least per day. His job was to be in the parking lot picking up carts, and 2 employees on the day when plaintiff fell were in the area and actually ran to her. So that satisfies the notice. Just because they didn't do the proper inspection, that doesn't mean they can just say, well, I'm not admitting to seeing it, so I didn't have notice.
All right, Mr. Lyle, go ahead.
As I was saying, Your Honor, there are 2 parts. Number 1 is actual notice. There is no summary judgment evidence that Pay and Save or any of its employees had any actual knowledge of the condition in question prior to the incident. Okay, number one, actual knowledge. With regard to whether or not they had any constructive knowledge, again, plaintiff's argument glosses over the fact about there being any sort of a duty to do any inspection. Quite frankly, they have no duty, and the only evidence is the summary judgment evidence that the contract between EP Samana and Pay and Save clearly places the duty upon the landlord. And once again, plaintiff kind of glosses over the fact that this is, quote, a premises. It is, in fact, a premise. Okay. It's just not Pay and Save's premises, because Pay and Save premises stops at the threshold out there. And so with regard to the whether or not they knew or should have known, I agree with plaintiff's analysis. It is plaintiff's burden, and the court well knows that it's called the time notice rule. And you've got to show by competent summary judgment evidence how long a condition existed before they can recover. And in this particular case, it fails for two reasons. Number one is there is no evidence other than the owner's rep for the landlord indicated that he thinks it had been there for more than a day or so. Well, again, that's a guess, and he didn't know, and the plaintiff has not come forward to show how long that condition existed, number one. Number two, there is no indication. Matter of fact, the summary judgment evidence is that the Pay and Save did not conduct inspections because it was under no obligation to. And what plaintiff attempts to do is hang upon Pay and Save some sort of liability because they acted as a good Samaritan, because the testimony and the summary judgment evidence is that they expected their employees to use common sense. And that is, if they saw something that they considered to be an issue, they were to report it so it could be reported to the landlord. And in this case, there's no evidence that it was ever noticed or there was ever any indication that Pay and Save had any knowledge of that at all. The next issue that I recall was that plaintiff makes an argument about control. There's no summary judgment evidence that Pay and Save had any right of control or exercised any control over the area in question. The only summary judgment evidence was that there was some cart corrals in a different part of the parking lot that they had constructed. The key case that this specifically addresses this is the Alexander versus Walmart case, which is cited in our reply. And it's very it's incredible, but that Alexander case is actually virtually identical to the fact setting that we have here. What we had in Alexander was we had Walmart, who was the tenant of the building, and a landlord who had the control and under their lease, the responsibility to maintain and inspect the common areas and the parking lot and sidewalks. And so they took the same position that Pay and Save here is that it's not Pay and Save. In that case, it wasn't Walmart's job. It wasn't their duty to go out there and inspect. The court made a very narrow exception and extended liability to Walmart in that Alexander case, because the evidence in that case was that without any sort of authority or without any sort of permission, Walmart went out into into the area controlled by the landlord and installed the ramp, which was the condition which was in question about causing the injuries to Mr. Alexander. So we don't have that here. And it was a Supreme Court case where they looked at it and said, well, yeah, Walmart, you'd probably be right, but for the fact that you did it, we do not have there's no summary judgment evidence that that there was any sort of connection like was in the Alexander case. So we believe the Alexander case controls. The next thing is that the plaintiff argues with a very broad brush that the plaintiff was a invitee of Pay and Save. This is, well, not only is it quite frankly ludicrous, their contention, but it's not supported by the summary judgment evidence. If you use plaintiff's logic, then you'd have to believe that once the plaintiff decided that she was going to go to the grocery store, that she was an invitee, that she was an invitee when she got in her car. She was an invitee when she got out of her car in the parking lot. She was an invitee of Pay and Save. And then as she walked across the parking lot, across the sidewalk, and then when she went in the store, we agree that as the premises owner and in the business of selling groceries to the public, that Ms. Finkley was an invitee just as soon as she stepped over the threshold into our store. Now, once she finished shopping and she departed, she was no longer an invitee of Pay and Save. And if you believe what the plaintiff is arguing, then she's an invitee forever. So where does it stop? They want you to believe that even when she walked out into the parking lot, which was controlled and maintained by EP Samana, was she not an invitee there? Well, what happens when she got in her car, assuming this accident didn't happen, and she got in her car and she stopped at Starbucks on the way home? Is she still an invitee at Pay and Save? No, it makes no sense. And it's a very broad brush that the plaintiff uses to want to extend liability when there is none. And quite frankly, it doesn't survive the scrutiny of having complied with summary judgment evidence rules. There's no summary judgment evidence that she in fact was continued to be an invitee when she left the store.
But Mr. Lyle, I mean, it's not like, I mean, Pay and Save provided shopping carts. They didn't require customers to leave the shopping carts in the store. You had corrals for shopping carts in that parking area. I don't know if Pay and Save did any kind of, I don't even know if this is possible, but with a shopping cart to make it less likely to land in one of these holes in the parking lot. I mean, you know, the extension of what Pay and Save may or may not have control over went beyond the doors of the store, right?
I'm sorry, I didn't understand that, Your Honor.
So I think you're trying to draw a line at Pay and Save's responsibility, I guess, at the door of the grocery store. Is that what you're suggesting?
What I'm saying is, the point I was making was that the plaintiff continues to contend that once the plaintiff walked out of the store, that she continued to be an invitee, and that's not supported by the facts or the law. She is now left the premises. She's gone off into someone else's premises, and that is the landlord's. Now, she did, in fact, take our cart, but there's no allegations that the cart in any way caused this particular action. It was involved, but they haven't alleged that somehow or another it was defective or that somehow or another it caused this problem. And so the fact that someone, utilized with permission a cart does not extend liability in our position, and don't believe that the law supports that as well. Now, with regard to this particular issue, this crack that was at the end of the sidewalk, and it was right up against the parking lot. It just so happened she was pushing a cart, but if they're complaining that was a dangerous condition. But if it was dangerous enough to catch the wheel of the cart, then it was dangerous enough to step into. Okay. And so quite frankly, the fact that she was using a cart or utilizing a cart that she took from our store, I don't see how it extends liability, Your Honor. Let's see. What we've got is we have the traditional and the no evidence MSJ against the plaintiff. Now, the plaintiff has not come forward with competent summary judgment evidence to create a material issue of fact as to each one of the elements of the claim for premises liability. Conversely, on the traditional, they have failed to come forward with competent summary judgment evidence to create a material issue of fact or controvert it as to liability on the traditional MSJ. I remind the court that when we started this last week or whenever it was, it was a lifetime ago, that we brought to the court's attention that there was no argument or summary judgment evidence brought forward by the plaintiff with regard to the claims of active negligence, ordinary negligence, negligent hiring, supervision, training, that sort of thing. So at a minimum, that we believe that that's not an issue and that should be granted. But that, quite frankly, this summary judgment, both of them, both the one against the landlord and against the plaintiff, does not impair this lawsuit from proceeding forward to allow the plaintiff redress for her injuries. Matter of fact, it streamlines it. It makes it much more simple because when you look at these, and this is one of the reasons why we waited to have these cases heard together, because they dovetail. And that is while there may be a claim for indemnity under the contract between the landlord and the tenant, we don't believe that it's enforceable. And that's a red herring issue that would be heard before the court, before the jury. And secondly, this whole issue about inspection. And I mean, the testimony and the summary judgment evidence was that the owner's representative for the landlord says that's something that they should have caught. And they didn't. But, you know, Pay and Save is in there and has no responsibility or duty to inspect or to maintain those areas, but they've been drug in. And so we don't believe that the plaintiff has complied with its obligations to come forward on the no evidence and has failed to come forward and refute and create a fact question on the traditional summary judgment, and that all the summary judgments should be granted as requested, Your Honor.
I want to be clear, Mr. Lyle, you objected. Can you tell me in terms of the summary judgment evidence that plaintiff provided, which ones you were objecting to, just so I can take note exactly of which ones they are? Is it the photos and what else?
Well, the photos and then this, I can't remember the name of the case off the top of my head. I believe it was the United case that they attached and marked as an exhibit, not just as an authority, but as an exhibit to the summary judgment, which was proceedings in another case. Understood.
All right. I think I have this pretty, well considered, and so I don't know that I need any more argument. I think I've asked for proposed orders if you haven't already provided, I believe I asked for them last time. I do want to return and look at those exhibits that Mr. Lyle has mentioned. And so with that, unless you all have something else for me, I'm going to have a ruling for you this week.
Would you like us to kill a couple more trees? I'm sure Your Honor has a number of books in her chambers on this case.
I do. I don't need any more trees killed, but I don't know what you're suggesting, Mr. Lyle.
No, you know what? I was just being a little flippant, Your Honor. There was, for the issues involved, there was a whole lot of paper involved in providing that to the court, Your Honor.
Well, and you know, I don't want to be called a tree killer necessarily, but I don't mind paper, and I do appreciate you all providing the court in advance. And also want to thank you for, you know, we ran out of time last time, and so your flexibility in coming back and requesting the extra time timely so that we could get you all scheduled and take care of it is really helpful. And I apologize for any inconvenience that may have caused you all. In any event, if there's nothing further, I know we had a status conference last time. I don't have in front of me the Odyssey settings. And so when is our next setting?
Looking that up.
I believe we're set for trial in February, Your Honor.
Do we go all the way to the trial? Is that what happens? I mean, is that what our next setting is?
The next setting, actual
Other
judge,
than pretrial.
it's the 29th of November.
Final judges.
Okay. Final judges. Okay. All right. Well, in any event, if we need to broach something outside of this hearing, I'll let you know, but I'm going to continue to do my final review, and then I will have a ruling for you. It probably won't be the end of the week. It'll be sooner than that.